Hello friends, you finally have your mediation conference scheduled in your divorce proceeding. You received a notice of mediation, you're looking at it and you're thinking to yourself, well, what are the next steps? Today we've got you covered. We're going to talk about how to prepare for mediation. Welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. All right, before we get started on how to actually prepare for mediation, remember that mediation or a mediation conference is simply a meeting. This meeting is chaired or guided by a neutral mediator who is either agreed to by the parties or appointed by the court. Each party will have their legal team with them at that meeting as well. So the parties, if they have attorneys or counsel of record, they will go to the mediation as well. And each side may have some experts. So if there's a forensic accountant, financial planner, some sort of vocational expert, or some sort of expert. If there are issues involving children and the court appointed a guardian ad litem, the guardian ad litem will also attend the mediation conference. The mediation will be set for either a set amount of time, either 2 hours, 4 hours, or an entire day, and it will take place at an agreed to location. It's important to remember that a mediation conference is a big milestone in a divorce case. I say this because a lot of jurisdictions require the parties to attend mediation before the court will set the case for trial or for a final hearing. What's great about mediation is the parties can agree and settle the entire case, or they may be able to settle part of the case. It really depends on how many issues there are and what the parties are able to agree to. So whatever's agreed to and signed off at mediation will be resolved, and the remaining issues will either be set for trial or go to court. Since this is such a huge milestone, I will say this as number one. It is important for a party to meet with their attorney prior to mediation. Our firm treats it almost like a medical or dental appointment. Whenever we find out when the mediation is set, we automatically send an appointment at least 2 weeks before the mediation conference. This way the client can make whatever accommodations they need, either for work, for school, or for the kiddos if there's children. The client will also have that 2 weeks in between the mediation preparation meeting and the actual mediation date to gather any additional documents that are either missing or that may be needed, and we'll give them time to kind of process what's happening. So that's how we approach it. Either way, the mediation preparation meeting is a great time for the attorney and the client to get on the same page. The client can inform the attorney as to what the priorities and the goals are. Some clients come in and are like, we want to finish yesterday, that's it, we just want this case to be over. Other clients want to just address maybe the children's issues and leave the financial issues for later. If a case is a little bit more complicated, it may work that way, where different parts of the case are settled at different times. We also get to instruct the client that there is a possibility that the entire case may settle, but maybe only part of the case will settle. So there's pros and cons about that. And we can also reiterate to the client the pros and cons of what happens if mediation doesn't resolve any or all of the case. That means the case will go to trial, and we can have an honest and open conversation about the client, what that would cost in terms of a trial budget, preparation time, and things of that nature. These are some of the things that attorneys and clients should discuss and that are important so that they get on the same page. So what we're going to do now is we're going to take you on a tour of some of the things that we discuss whenever it is that we have a mediation preparation meeting with clients. If there are children involved, that is the absolute first issue that we always try to address because it is the most important. We try to ascertain from the clients what is the most important part of the parenting plan and time sharing schedule. What are the most important days during the week and on the weekends? If there are holidays, school selection, special needs, as well as things that that client thinks are the most important. In addition to the time sharing schedule, we talk about child support. Oftentimes, we run proposed child support guidelines for the client. We have the same software that the court uses. It's called Divorce Power Analyzer. It's called DPA. We love that program because it gives you different scenarios of child support. If there's a guardian ad litem involved, we try to contact the guardian and see what their position is with respect to the parenting plan and time sharing schedule. So during our mediation preparation meetings, when we focus on the children, children. We like to focus on what suits the needs of our particular client. We also use this to educate them because recently the statute changed, and now in Florida there's a presumption of equal time sharing, and then there's some other information about when a schedule can be modified. Finally, as a pro tip, we always go into a mediation conference with a proposed parenting plan. Having a proposed parenting plan is huge because the client kind of knows what the ballpark is of what they want, and it saves time because if the parenting plan is already drafted, when we get to mediation, we don't have to draft that at that point. So a lot of times we walk into mediation with a parenting plan that has been approved and reviewed by our client. When it comes to property division, what we here in Florida call equitable distribution, whenever we have a mediation preparation meeting with the client, we like to run the different equitable distribution scenarios. So if there's a forensic accountant on the case, the forensic accountant is with us during the mediation preparation meeting. If there's some other financial expert, whether it be a vocational expert or business valuator, that person or that part of the team is with us when we meet with the client in anticipation of mediation. When it comes to equitable distribution, it is our practice to always try to collect and organize all the necessary financial documents in a case. First, we're going to focus on the asset side. When it comes to the asset side, and if there's real property or real estate, it is imperative to have the appraisals handy. The appraisal report needs to be done. It needs to be current. Appraisal reports that are a year or 2 years old don't reflect the current market conditions. If there's a business in the marriage, we try to put a value on the business, and it has to be a current one and or a value at the time of the filing of the petition for dissolution of marriage. If there's a vocational expert that talks about the employability or the income of the different spouses, we make sure that we get that report as well. We make sure that we get the most current statements, whether they be bank statements or savings account statements. If there's stock portfolio, any type of retirement accounts or pension statements. If there's going to be a qualified domestic relations order, we start figuring out who we're going to send that out to. And we try to figure out what is marital, what part of the retirement or pension is marital. Is there a life insurance policy? Who's the beneficiary? What is the value of it? When it comes to automobiles or boats or motorcycles or any type of collectibles, we need to figure out what the fair market value is. When it comes to automobiles, the Kelley Blue Book value is a great rule of thumb, but when it comes to boats, it may be different. You might have to look on some of the pages that they sell boats on. And when it comes to some collectibles, you may have to hire an expert to value or appraise that particular piece of personal property. Next up may be crypto. As we all know that the crypto market is very volatile. We need to make sure that we know the present day value of the crypto asset because we want to know how it's fluctuated since the time that someone filed for divorce. And finally, sad but true, we did a whole video on fur babies or pets. As you all know, pets are chattel in Florida, so we need to get a value on the pets. So that's kind of like a little bit of a rundown on how we process our mediation preparation meeting when it comes to assets. On the liability side, whenever we have our mediation preparation meeting, we are focusing on all of the parties' debt and statements regarding that debt, starting with the mortgage statements. Those mortgage statements have payoff. They also have the balances at the time that the case opened, as well as when the parties were married. And they have a present statement that'll tell you what the actual balance is on that mortgage. Is there a home equity line of credit statement? Are there credit card statements? We need to get those statements. The student loan statements. We also have to contemplate possible future expenses. Is one of the spouses moving? Do we need to cover moving expenses? Is there going to be IRS tax consequences? We're not tax professionals, so we always tell our clients to speak with an accountant to see how this whole settlement may affect them. And finally, IRS debt. I told you, don't mess with the IRS. And a lot of times the couples will have a different filing status if they're divorced before the 31st of December of each particular year. So these, when we run through our mediation preparation, we're not just looking at the good stuff, we're also looking at the liabilities. Now that we have discussed how we run through our mediation preparation meeting relating to assets and liabilities, making sure that we get the most updated financial documents for both, it is important for me at this point give another practice tip. It always helps to walk in with a rough estimated equitable distribution chart. It helps because it assists the client in trying to see the negotiating process and where the assets and liabilities kind of fall. This helps the client become more educated and be able to advocate better on their own behalf. Now that we've discussed how we prepare for the issues relating to the children, like the parenting plan and the time-sharing schedule, as well as the issues relating to equitable distribution, we must now talk about alimony, because we always discuss with our client the possible alimony ramifications of a case, and the big ticket item is income, the income of both of the parties. How do we find out what each of the parties makes? And it is important to get up-to-date and relevant financial information. Remember that income, when it comes to both child support and alimony, is governed under Florida Statute 61.30. I invite all of you to read that statute because it lists all the things that a court will consider income. Some of the things or some of the financial documents that we would be really interested in getting before a mediation conference so that we can run different alimony scenarios is the tax returns. Obviously, the tax returns of the parties, as well as pay stubs. Pay stubs are great because it gives you year-to-date earnings. It also gives you information about medical and sick leave, bonuses, commissions, the bank statements, as I mentioned before, any type of disability benefits, compensation benefits, as well as Social Security payments, any rental income, and in-kind payments, the infamous in-kind payments when someone is paying some expense on behalf of one of the spouses on a recurring and monthly basis. Before we move on to the next part of this video, it is important to also note that if the client and the attorney believe that they don't have sufficient information either to address parenting plan issues with the kids or the property division or the alimony, they may discuss and decide that they should file a motion for continuance, because it's important to have all of these documents. And if the documents aren't there and the attorney and the client make a decision that it is impossible or it is not warranted for them to move forward at this point, they can file a motion to continue the mediation. It may slow the process down, but at least the client will have all the information necessary to make an educated decision when they decide to settle the case. Now let's talk about what happens when the mediation conference is actually set. First, clients probably are going to check the reputation of the mediator. How long have they been practicing law if they're attorneys? If not, how long have they been mediating? It's important to select a qualified and experienced mediator that is neutral and that can facilitate productive discussions about the case. However, do not call the mediator separately if you're represented by counsel. There's no need for you to call. Your attorney and the opposing counsel will reach out to the mediator when necessary. There must be a decision as to whether or not having mediation in person or on Zoom is the best choice. There's pros and cons for both. It is important for clients to be emotionally prepared for mediation. Consider seeking support from family, friends, therapists prior to mediation. Make sure that we get a good night's rest prior to the day of mediation so that we're focused. And then obviously mediation, the process itself, is very interesting. It is important for the clients to familiarize themselves with the mediation process. This includes knowing the rules and what the mediator's role is. Obviously, there's an initial meeting. Then usually in divorce cases, the parties caucus or are separated, and then the mediator will go in and out of the room of each of the parties, either the Zoom room or the regular room. Whenever the mediator's in a separate room, it's called a caucus. Clients shouldn't feel bad if the mediator spends more time with one person than the other. It may mean that they just have to explain more. Towards the end of the mediation, there may be an agreement. If there is, there's an inherent waiting game. So it's important to be a little bit patient, because that is what's called the drafting period, when the parties or the attorneys are drafting either the marital settlement agreement, the property agreement, maybe a parenting plan. That is why the initial draft of these documents is so important, because it saves on some of the time in drafting these documents. As our tour on how to prepare for mediation comes to a conclusion, some final thoughts. First, clients should be patient and respectful. The mediation process is exactly that. It is a process, and sometimes it takes a little bit longer. It has its ebbs and its flows. It can be frustrating and challenging to stay in there sometimes, but at least try to be respectful and patient. Also, approach the mediation process with an open mind and a collaborative spirit to see if the case can be resolved. Remember that they're two different people and they view the world differently. The goal is to try to work through that process. The goal is also to try to find a mutually agreeable solution to the case so that the parties don't have to go to trial and incur additional fees and costs if possible. All right, so that is a wrap on how to prepare for mediation conferences. If you know anyone that might find this information interesting, have them look us up at www.segarralawfirm.com. We have offices in Miami and Orlando, Florida. Se habla español. Do us a favor and like this video. Please subscribe to the Divorce Broadcast and put in some comments below so that we can respond to you about how to prepare for mediation. Thank you.